Minister, I'm obviously glad that finally we have a bill before us on birth information and tracing, whose stated objective is to end the shameful situation where, for decades and decades and decades, people who were adopted and mothers who were in effect forced to give up their children, even if sometimes it was technically consensual, in reality, given the stigma that was imposed by church and state on women who had children outside of marriage, the general culture that existed, the anti-women culture that existed, the culture of shame that existed and was perpetuated by church and state. In reality, the vast, vast majority of adoptions in that kind of environment were in effect forced adoptions, forced separation of mother and child. So a bill that attempts or sets out as its objective to end that denial of identity, history, heritage to adoptees is to be welcomed. But unfortunately, Minister, this legislation, while its stated objective is to address that long battle that adoptees and mothers who are forcibly, effectively separated from their children to the information they're entitled to about themselves, this bill does not come up to the mark in terms of achieving that. And before I go into the provisions of the bill itself, let me say, just because I met with some of the Tuam families outside yesterday, and they asked me to say that as well as the issues that are addressed in this bill, they wanted me to impress upon you their continuing anger, and it's one I share, at the insulting form the redress scheme has taken in terms of this arbitrary 6 months date, and that you, in order to avail of the redress scheme, that you have to be 6 months in an institution. I've made this point previously to you, Minister, and the sort of league table, as it were, of financial compensation, which is frankly insulting and dehumanising of the people that we're supposed to be providing redress for, to sort of, in a league table format, assign a particular monetary value to the trauma, the hardship, the suffering that people went through, and to arbitrarily exclude many, many people on the basis of this 6 month line. It simply beggars belief, to be honest with you, that given the acknowledgements, the verbal acknowledgements we've had about what, the wrong that was done to adoptees, to mothers and so on, in the mother and baby homes, the various institutions of a similar sort, that there's a failure to actually, when it comes to redress, really approach the issue from a human point of view. Because it is precisely the dehumanisation that is at the heart of the wrong that was done to children and to mothers for decades in this state. And I would ask the Minister to seriously reconsider all of that. The exclusion, the other issue they asked me to raise, is the exclusion of many, many institutions from that redress scheme. It's just not acceptable. I mean, as I've said to you many times, I'm an adoptee, as you know, Minister, and generally speaking, my situation has turned out to be a lucky one, in that I, had a wonderful family adopted me, and later my birth mother, with some considerable difficulty, which I'll get on to in terms of the provisions of this bill, was able to find me. So I've had a happy outcome. But for many, many, many people, that is not the case. They've suffered terribly. They suffered abuse. They have never, found out the full details of their history. They haven't had that reunification. Their mothers may have died in the interim. There is a terrible, terrible suffering that has been endured by many people and continues for many, many people. And that is not limited to the institutions that are named in the redress scheme. Temple Hill, where I was, for example, one of the mother and baby homes, as far as I know that I was in, is excluded. And a lot of people went through Temple Hill. That's not a major issue for me personally, but for many it is. And one of them was out there yesterday as well with the Tuam families, saying, why have we been excluded? And they also asked me to impress upon you the urgency of getting that right and getting the redress scheme up and running. Because the other point they made was that many of them are very elderly. And it may all be too late for them unless we get this right and get it established and deliver the redress as a matter of absolute urgency. So that's the first thing I want to say to you ahead of discussing the provisions of the bill. But on the bill itself, what is required is best summed up, I think, probably in a phrase by the Clan Project when it said, what we want is the file, the whole file, and nothing but the file. And this legislation does not achieve that. And I will listen, and I know the Minister is genuinely engaged with this, and I know he's put considerable effort into it. But I also think we need, and I've said this all along, and I think it's what was lacking with the Mother and Baby Home Commission report, is we have to put the survivors, the mothers and children who went through these institutions, who suffered the forced separations, we have to put their approach to it, their needs, their hopes at the centre of getting this right. And certainly many of them feel that is not the case, and when I look at the provisions of this bill, it is lacking in many respects. Now, I do acknowledge, by the way, Minister, that it's an improvement, okay? So I'm not disputing, it's an improvement. And as I said, despite the happy outcome I have largely had, there are gaps in my history and information that I still would like to fill, and I will certainly be making an application for my information, if nothing else, to test out, does the system work as soon as it's up and running, not just on my own behalf, but as somebody who's a public representative and wants to see, is this legislation actually going to deliver what the government says it wants to deliver from this legislation. And one thing that has been requested by the survivors groups, the adoption groups and others, is that there will be a stakeholder group involving the survivors who will oversee the implementation of this legislation and be allowed input to any necessary ongoing, well, there should be an ongoing review of this legislation to actually improve it, to fill the gaps and to make sure that it actually delivers for the people who it's supposed to deliver for. And I think that request and that proposal needs to be taken on board. And it has been lacking having that approach of the stakeholders, the survivors and so on at the centre, most egregiously manifested in the failure to attribute the proper weight in the Commission report to the testimonies of the survivors, and some of the quite frankly insulting summary and recommendations that were given as a result, because there wasn't the proper weight given to the testimonies of the survivors. And similarly with this legislation, I think the voices which have emanated from the survivors groups, from people like the Clon Project and the various other campaigning groups representing the survivors, and to a large extent reflected in the recommendations of the Joint Committee, many of those recommendations have not found their way into the legislation. And of course, the most egregious of those, if this is about, and it should be, accessing the file, the whole file, and nothing but the file, is the fact, as something that is required under GDPR, that people should have the access to all of the information relevant to them, their history, their heritage, the history of their care, any files, administrative or otherwise, that some of those rights are conditional or caveated by the requirement to have an information session if there is a no contact preference stressed by the mother. Now that is just not acceptable. I mean, first of all, it assumes, which one should not assume, that adoptees necessarily want contact. They don't necessarily want contact. So you're bringing something into the equation when simply people are looking for their birth information, looking for medical information, looking for the gaps in their history and their heritage and their identity, things that have been taken from them, that they are entitled to under GDPR, but they are entitled to morally in any event. Why would we then import into that the assumption that they need to be lectured about seeking to contact their birth mother or their birth parents? Why would we do that? And secondly, why would we make it in any way conditional on their accessing the file, the whole file, and nothing but the file, receiving a lecture or warning around not contacting somebody when a no contact preference has been expressed? It's wrong, it's insulting, it's unnecessary, and it should be removed. It should be removed from the bill. And despite the fact that the bill makes references to GDPR, it then in effect, and some are suggesting that it is in fact illegal, the caveats and the conditions and the obstacles, if you like, that are being put in the way of people actually having all the information that they are morally and, I would say, legally entitled to. So that is obviously critical, but there are other issues. The question of plain English is critically important as well. The bill, I find the bills, I still haven't fully got my head around the bill. I have more work to do on it before committee stage, when we will certainly be putting in amendments to the bill. But it's a complicated and difficult piece of legislation. Now, I know legislation sometimes has to be, but extra effort needs to be made to ensure that all survivors, anybody who is seeking to get their birth information or to trace their parents and so on, it has to be accessible to them. How to do that has to be fully accessible. The issue of not acknowledging fully the illegal and unlawful adoption issue, but referring to it as incorrect registration. Sorry, I'm confusing 2 points there. That's not referring to incorrect birth registration rather than, as was requested, that it would be falsely or incorrectly recorded, where we know there was falsification of records. I don't see why you wouldn't concede that point, and it is very important given that that was a crime to falsify records. It's not just a mistake, it's a crime. And that needs to be acknowledged in the legislation, and of course illegal or unlawful adoption. The other point is about people's right to access all of the information from other institutions directly, the religious organisations or institutions directly, rather than having to go through the gatekeepers of TUSLA and the Adoption Authority. It seems to me that has to be included. That people should have the right to go directly to the religious orders or to the bodies or individuals who were in charge of their adoption, in charge of these institutions, to directly get all of the records, information, items that may relate to their adoption and their care. That should be provided for in the legislation. Clarity and training for the people who are going to oversee all of this and assist people with the tracing and providing people with the information. We need to make sure that we have the staff resources and that we have proper training, and that training includes full knowledge of GDPR and compliance with GDPR, with no caveats or no restrictions or obstacles to people's right under GDPR. There are other things I could bring up, but I will just simply refer the Minister to the recommendations of the Joint Committee and the failure to include many of those recommendations and the calls of people like the Clon Project, who are very concerned and dissatisfied with the failure to put their requests into this legislation. I will listen intently to the Minister's response to all of these things, and I do so with an open mind, but it seems to me there are major gaps, and they've been well rehearsed by other speakers as well, and I hope the Minister is going to respond positively for the calls to amend this legislation to make it better than it is. And sorry, one other very, very important issue I forgot to mention is the question of mothers and their right to all of the information regarding their children. And it relates to the first point about, forced separation for most mothers. This bill does almost nothing to enhance the very, very limited rights of mothers to access the information about the children they were effectively forced to adopt because of the culture, and sometimes actually forced, but more generally culturally forced and pressured into giving up their children. And as I understand the bill, the only thing this additionally does is allow them to get that information if their child died in the institution. That's just not good enough, Minister. That's absolutely not good enough. I know from personal experience, and I know from many stories I've heard, that often mothers who were in effect forced to give up their children then go, in the new environment we're in, go and seek out their children, that information, that history, and so on, and the difficulties they have encountered. They have been wronged too, and this legislation should be providing for them to remove those obstacles, that denial of the information about the children they were forced to give up. And I think that has to be also included in the legislation. So thanks, Ceann Comhairle. I eagerly await the Minister's response and indeed to the further discussion and hopefully amendment of this bill at committee stage.
Thank you very much, Deputy Boyd Barrett.